of himself, and he was happy to tell me all about it. And although that worked out successfully for him, that isn't exactly the way to handle violations. There should be a process in how you handle violations, because technically you could have ended up in court for doing something like that. The property owner could have filed a lawsuit against the city. So we want to avoid that kind of thing. So I want to give you through this seminar some tools to use to basically set up a process, a step-by-step method for how you're going to investigate violations and how you're going to notify property owners about potential violations. So let's get started, shall we? Now, what is floodplain management? And originally we were going to set this up with pop-up questions and let people type in the answer in the chat box, that kind of thing. But instead of doing that today, I'm just going to give you the answers. And by giving you the answers now, we'll save more time at the end, so I'll have more time for your individual questions. And floodplain management is a stick to beat your neighbor over the head with. Because whenever two neighbors are having a feud because somebody's dog barked and woke somebody up in the middle of the night, or somebody's car was half blocking somebody else's driveway, they start looking for ways to get even with each other. And then they start turning in complaints on each other. They'll turn in complaints for zoning violations or for floodplain violations. So as floodplain managers, we often become aware of violations through neighbor complaints as much as through anything else. And now that I've brought up violations, what is a violation? And this is the definition of it, the by the book definition, but essentially it's development that happens in floodplain that doesn't meet your regulations. And everybody's regulations require permits to do work in the floodplain. So just remember, anything that doesn't have a permit is a violation. And this term development, we need to talk about that because that's the root of a violation. What is development? Now, some people tend to think of development as being like real estate development, subdivision, but it's so much more than that. Development is any man-made change to improved or unimproved real estate. I'm going to give you guys a clue right now. There is no other kind of real estate except improved and unimproved. That pretty much covers it all. So any man-made change anywhere could constitute development. And I've got a list here in this slideshow, but this list isn't all-inclusive. And a lot of things get overlooked because people tend not to think, well, that's not development, it's just a new driveway, or it's just fixing a sidewalk, or it's just preparing the street, or it's just building a culvert, or whatever. No, all of those things do constitute development. I've had people had to get permits to pour a patio slab or build a brick barbecue in the backyard because those things do constitute a man-made change. Now, is a patio very difficult to permit? No, it's not. Is it a violation if they don't get a permit? Yes, it is. Now I've brought up the topic of permits. I drive around Kansas a lot, at least I used to before the virus, and I saw signs like this almost every county I went into. I'd get to the county line, bang, there's a sign. You know what I'd really like to see? I'd like to see signs like this that say floodplain permits are required. Because a lot of the time I'm working with people who've done stuff in the floodplain who claim they didn't know floodplain permits were required. And quite honestly, some of them were telling the truth about it. They just didn't know. Nice people who just, they would never knowingly violate a rule, but they didn't know the rule existed because they weren't educated about floodplain management. Now, today I'm going to go back to the topic of sheds a few times. Sheds are a common problem that I find in the floodplain when I go to visit small towns. And so I'm going to use sheds as an example over and over again. To make, so you're going to have a case example of a shed as kind of our talking point today. But remember, a violation could be not just a shed. It could be a garage. It could be a new house. It's any man-made change in the floodplain. It could be a patio slab, since I mentioned that earlier, okay? Now, when you're dealing with violations and you're meeting with property owners, you're talking to them, one of the first things property owners are going to say to you is, what gives you the right to tell me what to do on my own property? And it seems to be that the bigger the property is, the more right they assume they have. I used to work with farmers quite a bit in my previous job, and I got nothing against farmers, but farmers are kind of independent businessmen. And so they're kind of independent in their thinking, and they don't think you have the right to tell them what to do on their farm. So you better know what right you have to tell people what to do before you start talking to them. And so this screenshot has a few statutes on it. But essentially, in the state of Kansas, there are laws, state statutes, that give local communities the right to adopt floodplain management codes. And those floodplain management codes are your city ordinances. Sometimes it's a county with a resolution. Sometimes communities have it incorporated into codes. I'm just going to use the phrase ordinance today over and over again without saying ordinance/code/resolution. Now, because you have this codified ordinance that you have permission from the state of Kansas to adopt, whatever it says in those ordinances are things that you have the rights to enforce. There are also additional state statutes that apply. So the Division of Water Resources has regulations that regulate stream development. We also have Kansas Department of Health and Environmental regulations on things like septic and lagoon systems in the floodplain. So this is just kind of a list. Abatement is one we're going to talk about later. And that one 40-3901, that's one of my favorite ones. So I'm just going to talk about it right now. That's an insurance proceeds ordinance. Let me tell you how it works. You adopt an ordinance. You can get a blank template ordinance from the Kansas League of Municipalities. And up until 2016, this ordinance only applied to fire insurance. But after 2016, the League of Kansas Municipalities sponsored a lobbying of an amendment to change it to be any kind of damage. So let's say you had a home that was damaged in a storm. And I'm going to try to use the math, make the math easy for myself. I'm going to say it's a $100,000 house. And the storm causes $75,000 in damage to this house. That's 75%. Your city regulations say 50% or more is substantial damage. So it has been substantially damaged, and it has in excess of $75,000 in damage, which is part of our insurance proceeds ordinance regulations. 15% of $75,000 will not be sent to the property owner. It will be sent to the city. So the city is going to get about $9,750 sent directly to the city. I should have got my calculator out before I did this one. The city will hold that 15% in an account that bears interest. They don't have to give that money back to the property owner until the property owner brings the building into compliance with city codes. So now you have a powerful incentive for the property owner to elevate their house or floodproof their business or bring their property into compliance because you're holding 15% of their insurance money. And they don't get it back until they follow your rules. And so I like these little ways to help bring violations into compliance by having these little tricks up our sleeve, I guess you'd say. So when does enforcement start? And I've got a list here. This was another one of our pop quizzes, but essentially enforcement begins whenever you become aware of a violation. So if you're driving down the street in your town or your community and you see somebody building a garage or there's a shed in the backyard of a house and you're aware that there's a stream back there and that's probably in the floodplain, then it becomes incumbent on you to go and investigate that violation. I had a community official once tell me that she would only investigate complaints if there was a complaint turned in, and she would not investigate anonymous complaints. So she basically didn't investigate 90% of the violations in the community. Now, you all have floodplain ordinances, etc. And those codes don't say, we agree to enforce the floodplain regulations in our agreement with FEMA under the National Flood Insurance Program, just so long as there's an anonymous complaint turned in on them. No, that's not what it says. It says you're going to enforce everything, everywhere, all the time, because that's important to do. Now, this is a list of actual reasons that community officials, floodplain managers in most cases, have given to me for not enforcing their regulations. The B on this one is the one I hear the most. I'm too busy. Again, if you allow violations to happen in your community and you don't address them, can you go to FEMA and say, hey, I'm just too busy to enforce our floodplain regulations, so you have to give me a free pass? Is that going to work out for you? I don't think it's gonna. No. I wish we had somebody from FEMA here to confirm that. All right, now, Keeping it moving. What is the key to enforcement? Think about it for a second. I'm going to give you the answer, and you probably hit on it already. It's consistency. Be consistent. Not only do I mean that you enforce all your regulations all the time and investigate all violations, but also mean be consistent in how you enforce against violations, okay? And so we're going to talk about a process today for investigating a violation and notifying property owners. Then we'll expand that process in tomorrow's seminar for those of you who are signed up for it to talk about how to meet with property owners and how to take a case to court and so on. All right, so you've become aware of a violation. It's a shed in somebody's backyard and it doesn't have a permit. You saw it while you were driving down the road. So you're gonna go back out there and take a look at the shed, take a photograph of it. Before you leave your office to go out and have a new look at that shed, do you look at flood maps to see where the floodplains are? Do you have a GIS information system, geographic information system data that you can look at? Maybe you print a map to take with you to the field. Maps are handy because you can see an aerial picture on the map where the floodplain stops and starts. So if you can see on the map, well, the floodplain starts about 20 feet behind the house and the shed's easily 40 feet back of the house. You know your shed's in the floodplain from the street, just looking at the backyard from the front of the property. You don't have to go stand next to it with a tape measure sometimes. All right. If you're close, you can call it in and then investigate it further when the property owner talks to you later. So if you make maps before you go into the field, or if you look at maps on your computer, I suggest you save your maps in a file. You're going to start an investigation file. There's two reasons for this. A very few cases, very, very few, actually end up in court. Most are resolved without going to court. But if you ever go to court, documentation is important. Another reason is that some cases, sometimes, there will be property owners who will try to basically create a smokescreen and say that you are the problem. They're going to say that darn Steve Samuelson is picking on me because he hates farmers and I'm a farmer. You know, just nonsense like that, okay? So people will try to flip it around and say you're the problem instead of their violation is the problem, and turn in a complaint to your mayor or somebody about nonsense like that. And what is your best defense in a situation like that? Having good records. So the good records are a CYA tool. If you don't know what CYA means, get with me when I'm not talking and being recorded and I'll tell you what it is. But having good records can cover your rump when you are dealing with somebody who's trying to create a smokescreen and say that you're the problem. And it's also invaluable if you ever have to go to court. Document, document, document. I almost encourage you to over-document violations. To start a file for every violation. Here are some more maps that you might look at before you go to the field. If you're in a larger city and you've had a complaint turned in on a street address in a big town that some of the people that are on this call are from big cities, and they haven't been to every house and every street in their city yet because the city has several 100,000 people. So do you look at a locator map to make sure you can find the right address? What about the FEMA flood maps? Do you make fermets of the FEMA flood maps? I used to make fermets all the time because I could print them out 8x11, save them as PDFs, keep them on file real easy with permit forms, which are also printed on 8x11 sheets of paper. Do you look at resources like Google Earth? Here in this picture, you can see a Google Earth image from 2011 and another one from 2014. And it doesn't take anybody with any great intelligence to see that there's been a change in the picture from 2011 to 2014. Right about in the center of the screen, there's a great big purple rooftop. And if you look down in the lower corner of the screen, there's a state highway. So somebody was driving down the state highway and saw that new building had been built in the floodplain. Then that person checked on Google Earth and just looked to see that some of the trees next to the stream channel had been removed to make room for that building. Then looked at the flood maps, and about half of that building with the purple roof is in the floodplain. The building with the purple roof is a new house. They definitely need permits to build new houses in the floodplain. I think everybody can agree with that as a definition of development for sure. Do you look at building permit records or other records that you have on file? I used to work regularly with my county appraisers, and they would let me go into their record rooms, and then I could look at their files to see when they had picked up a new garage or room addition or deck that had been built onto a house for property tax purposes. And that told me exactly when it got built. That's important because sometimes you have flood maps that change. When flood maps change, you may need to look at the previous flood map to see if the property might have been out of the floodplain at the time that the development occurred. One of those loopholes. All right, now you get there. You've done your investigation. You're out in the field. You're going to take a picture of our shed that doesn't have any flood openings and doesn't look to be anchored. I used to take pictures that looked a lot like this one, and I was wrong. So I want to tell you what I did wrong so you can learn from my mistake. Now this looks like a fairly decent picture. You can actually see at the left-hand edge of the picture how the ground slopes upward and how this shed is down in the floodplain. But one of the problems is that if you ever go to the lumber yard or the home supply store in your community, you'll see sheds for sale. And what the guy at the lumber yard does is he paints all the sheds the same color. He doesn't paint a shed gray with white trim and then throw the half gallon of gray paint away that he has left over. No, he paints the next shed with it and the next one after that. That's why all of those sheds at the lumber yard are all those earth tone kind of colors that you see. And a lot of them will be painted the same color. And after you buy this shed, he's going to put another one out there in the lot and paint it the same color too. So this shed, although it's a nice close-up photo, there's nothing that says this shed is in an exact location. This could be any shed anywhere that was bought at the same lumber yard where they sell sheds in the parking lot. So what you want to do is create an establishing shot when you get there. So when you arrive on the property, step out of your car and take a wide shot that shows as much as you can. Now in this one, I had to crop it off a little bit because there were trees at either edge of the picture. So basically I widened it out till I got everything except the trees in the picture, and you wouldn't have been able to see much from there anyway. But here you can see our house on the left and our shed on the right. You can see the lay of the land. There's also a landmark in this picture. There's a fire hydrant. There's fire hydrants on most blocks, but every city and every house doesn't have a fire hydrant directly in front of it. So that's a landmark. Fire hydrants aren't the best landmarks around. There are other good landmarks. Here's one of them. That's a street sign. There's no doubt in anybody's mind who looks at this picture that this is the house at the corner of State and Village. This was a house that we were looking at after flood. You can see they've been carrying the debris from outside the house and piling it up beside the house over there. So this is a house that got flooded, and we were out doing damage estimations. We took this picture, but this is an excellent landmark type photo. Another good thing to have in a photo is the stream source. It doesn't mean you're always going to see water, but a lot of times when there's a stream channel, there will be trees growing along the embankment. So if you get that row of trees in the background of your picture behind your shed or your house, that shows you how close the flood source is to your development issue. So establishment shot, good rules for an establishment shot: wide angle, taking in as much as you can, stream source if possible, and look for a landmark to include in the photo. Sometimes that means you walk over the side, take your photo at a little bit of an angle and stay straight on. And you know what you can do? You can take more than one picture. You're more than allowed to do that. I encourage you to take lots of pictures. Digital cameras are great that way. We don't have to go and pay for the film to get developed anymore. I know there's people in this call that are as old as me and remember doing that. Now, if you notice, there's a street in the foreground of the picture. So I'm not standing in the front yard of the house. In this picture, I actually stood on an island in the middle of the street, one of those little circular islands where cars go around. I could have taken the picture from the street and gotten closer, but I stood on this island. I'm standing on public property. There's a term. It's curtilage. If you are in your office working at your computer, jot that term down and do a Google or internet search of some kind for that term, curtilage, after we get off the line. What curtilage means is that it's the patio, the flower beds, the front porch, that portion of the lawn that you mow up close to the house. Those areas in the curtilage are considered to be protected exactly the same as the areas inside the house. So if I had gone and walked up the driveway or stood in the front yard of this house to take pictures of it and the shed, I might have been violating this property owner's privacy rights by trespassing in their curtilage. It's like same as if I'd have kicked in the front door without permission. Our forefathers put this information in the Fourth Amendment to the Constitution, you see. Illegal search and seizure, it's right in there. And if you go into somebody's property with the intent of enforcing a violation, you could be violating their constitutional rights. You would be surprised how many property owners who have never read the Constitution in their entire life will claim to you that you are violating their constitutional rights. I hear it frequently. Okay. Now, this is time for our 60-second lesson in American history. So, back during the Revolutionary War days, before 1776, the British ruled the colonies. And our ancestors were colonists. Some of us migrated later, sure, I did. But the colonies, what the British did was they passed a law. It's called the Stamp Act. It put tariffs on all the goods being imported into the colonies, the United States today. Those tariffs, to prove that, hey, they had been paid, stamps were put on the goods that were being shipped in. So the stamp was the proof the tariff was paid. That's why it was called the Stamp Act. Well, it made the goods more expensive. The money raised from selling the stamps for the Stamp Act and the tariffs was used to pay to have British soldiers stationed in the American colonies. And the job of those British soldiers was to enforce the Stamp Act. This wasn't popular with some of our forefathers who founded America. What the British used to do was kick in the front door and go in and search houses looking for goods that didn't have stamps on them. Well, the colonists didn't like that very much. They thought that was a violation of their rights. This led to things like the Boston Tea Party and events like that and our eventual revolution. So when they wrote the Constitution, our forefathers, the founders of our United States, put it right in the Constitution that we would not have illegal searches and seizures. So be careful how you perceive your way of doing your enforcement. You might even write it up that in your written procedures for how you're going to do enforcement, that you will take your pictures from a public street or public right-of-way, and that you won't go on property without permission. If you do need to go on property without permission, you will seek that permission in special ways. Now, I showed you an establishing shot. It's a wide-angle shot. This is a closer shot showing the house number on the street. So I want you to imagine a conversation, and it goes something like this. Mr. Samuelson, do you live at 2353 Riverview Road? And I might say, yes, I do, Mr. Samuelson. Then you show them next picture, and it's going to be that wide angle shot. So the wide angle shot, you go back to it, you say, and is this your house? And I might say, yes, that's my house. Then you show them the close-up picture of the shed, and you say, is this their shed? Well, you've totally set them up now. They have to admit that's their shed. They can't say, well, I can't tell whose shed that is. It looks like every other shed at the lumber yard. You've set them up. And all of these pictures are free because you can just take a bunch of them on your digital camera and save them all. Now, how are you going to take those pictures? You could take them on your phone. You could take them on an expensive camera. Very few cases end up in court, but imagine you do end up in court. Do you think some smart aleck lawyer will try to claim that you altered the pictures, that you did something to the pictures to change them, to improve them for your point of view? Maybe you changed the coloring, cropped them, lightened them, brightened them, I don't know. So save the raw data from the pictures, but they may also want to say, hey, I want to see the device you took the pictures with. Do you want to give up your phone to somebody if you took the pictures on your phone? Do you want to give up an expensive camera and not get it back for a while? So maybe you might want to consider putting in your budget for your next time around to buy an inexpensive camera. You can get them for about $100 at most department stores or on the internet. And they will have a medium range zoom, which is usually plenty unless you're dealing with great big large farms out in the countryside like I used to. And they will have plenty of pixel. So maybe you want to get yourself a special little camera just for inspecting violations. And then you'll also have that camera for other things that come up later like if you have to take pictures of damaged properties after a flood or a disaster. Now, I just mentioned it. Always save the metadata from the photographs. That's your proof that you haven't altered the photographs. And take tons of pictures, tons of them. If something ever does go to court, go through all the pictures you took with your city attorney. I know county people are out here too, but go through all those pictures and explain what's good or bad about each picture, and then let the attorney pick the photos. What this does is it means that you know in advance which pictures your attorney chose, and you're not going to get surprised by your own attorney in a courtroom by him showing you a picture that you don't remember. And just a little side note, just for fun, you might remember that they caught the BTK killer because of metadata associated with photos. So metadata trapped the BTK killer. What some of you don't know beyond that is that the BTK killer was the code enforcement officer for a city right here in Kansas. And that city's city ordinance said that the code enforcement officer is the floodplain manager. So this serial killer from Kansas was also a floodplain manager just like us. And he had some very interesting techniques for doing enforcement of floodplain violations. Have him teach a class sometime. Now let's look at some sheds. Now these sheds have fences in front of them. Anybody who's ever seen a fence like this, there's a general term for it. These are called privacy fences. That term privacy is in the very name of the shed. So you would think by the fact that they're called privacy fences, people expect to have some privacy because of those fences. Is it valid? Is it legal for you to stick your camera lens between the slats of the privacy fence? There's another fence over here that's barely 4 foot high. Well, most people are more than 4 feet tall, so I don't think the property owner with the 4 foot high fence has a right to expect privacy like the guy with the 6 foot fence does. Can you use a selfie stick to lift up your camera, or can you hold your camera over your head to take pictures over the top of a fence of things you can't see? Now, this is about a 6 foot fence. Is it possible that you might have somebody on your staff who's 6'9"? Yeah, sure. Okay. And that person would see over this fence very easily. But if you raise your camera over your head, it goes back to something related to intent. By raising the camera over his head, the man in the picture, me by the way, is intending to violate the property owner's privacy. So it goes back to intent. By intending to violate the privacy owner's privacy, that's the same as illegal search and seizure, because I'm trying to violate the privacy behind their privacy fence of their curtilage. Now, to take this a step further, imagine the situation here if you were doing this with your camera over your head, and what you didn't realize till you took the camera down and looked at the picture is that the property owner's daughter is sunbathing in the backyard. And she had removed her top to get some kind of all over tan going on. And she's 15 years old. Okay, now you're in big trouble. So I would strongly recommend against this. A question I sometimes get right now is about drones. The deal with drones is that they are new technology. They've been out for a few years. They're becoming more affordable every year and more prevalent. However, there haven't been a lot of court cases yet that have given us rules on what courts assume is proper use of drones. Now, I've had people say, well, I'm a commercial drone operator. I have a license to operate my drone for commercial purposes. I can do whatever I want. You certainly can do whatever you want for commercial purposes, but that doesn't necessarily apply to using a drone with the express intent of violating somebody's property rights. Using a drone for illegal search and seizure. There's a case out of New Mexico that says helicopters can't fly lower than 400 feet if you're using them to enforce regulations. And it has to do with rights of privacy. Well, there's no law yet that says how high or how low you can fly a drone to investigate a complaint. There are some rules that say for safety how close you can fly a drone to an individual person. And a lot of this goes back to intent. There was a zoning administrator, his name was Ian. He was investigating a zoning complaint. It wasn't a floodplain violation. He went down to the city shop and got a bucket truck. He just checked out a bucket truck, drove it over in front of the house, went up in the bucket so that he could see what was going on in the backyard of the fence. His intent in the bucket truck was to violate that person's right to privacy. I started to hear something there for a minute. Okay. Now, it's different if a city crew was out there investigating a broken streetlight. They were investigating a broken streetlight and they happened to see what was going on in the backyard and told Ian about it and took pictures. They weren't there intending to violate someone's privacy. The bucket truck and the city crew were there intending to fix the streetlight. So what Ian should have done was carried a slingshot in his car, aimed it at the streetlight, broke the streetlight, called the city crew to come out there and fix it. Okay, never mind. I'm going a little too far overboard there. Now, I told you, document everything. Document, document, document. So you're going to document everything, and you're going to keep those records. And like I said, sometimes people will take you to court, but a lot of times what happens is they just make a bunch of complaints, and it's all usually nonsense that the floodplain manager is treating them differently because somebody else was treated differently. They might say, well, this house did the exact same thing and you didn't make them get a permit. You didn't send them a violation letter. If that did happen, you send them a violation letter because if they're in the floodplain. Now, is this a violation? Now, we can all look at that and say, that is just so ugly, it must be a violation. But I challenge you to look in your floodplain ordinances and find the word ugly anywhere in there. So when you're talking to people about violations, you need to know your ordinances back and forth. You need to know what this is a violation of. Now, this one, it's not made of floodproof materials. It doesn't have any flood openings. It's not anchored. It's also a violation of some setback requirements they had in the community for zoning. So this is a bad deal here, sure. So it's a violation because anchoring, openings, floodproof materials. It's not a violation because it's ugly. Now this is another picture of a shed. Is this one a violation? It doesn't have any flood openings. It's in the floodplain and it's not anchored. However, this one is not a violation because on further research, we found out this shed had been there for over 40 years. The shed was put in place before flood maps existed, before the community joined the National Flood Insurance Program. The owner has maintained it, put new roof on it from time to time. Good for him. So it's not a violation because it was pre-existing. It was pre-firm, essentially. And one of the clues to that fact is that this shed is made with tongue and groove boards on the side of it. That's how they used to make them. They don't make them that way anymore. Talked about the fact that sometimes people build things without permits. Do outreach in your community about permits. If you're letting everybody know that they need permits, if you're making people get permits, if you're enforcing violations, sooner or later, everybody's going to know that they need to do permits. And then you won't have to even deal with violations for people who built without permits because everybody's going to know they need one. So we've got a violation out there. It's a shed. We've gone out. We've taken pictures of it. We've done some research. We've investigated. What's our next step? Well, our next step is to notify the property owner. So this gets us into sending out property owner notices of violation. If the work is ongoing, send a stop work order immediately. There's a form that says stop order on it, but you don't have to use a special form. You can send them notice through like certified mail and just type it in the letter sent by certified mail, stop work immediately. Excuse me. Need a drink of water. It is 1,000 times easier to gain compliance on something that hasn't been finished construction yet. So if something's only half built, it's way easier to get it brought back into compliance. So keep that in mind. Don't ever delay with violations. The longer you postpone dealing with violations, the worse the problems become. Now, how do you send that stop work order? You could drive out to the construction site and hand a copy to the foreman. You could deliver it to the property owner. But those avenues don't create a paper trail. And I've told you, document, document, document. So to create a paper trail, one of the things I like to do is send certified letter. That's the standard procedure you're going to hear people say. And we all know how certified letters work. We also know if we have a property owner that's doing something fishy and they know they're doing something fishy, they may not sign for their certified mail. So another method is to use a mailing affidavit. I used to use mailing affidavits. Sometimes I actually preferred them over certified mail. They were cheaper and easier to use, and they were just as effective. If you really want to do a good job, double up. Send a certified letter and a regular letter, a first-class letter, but have a mailing affidavit. Now, some of you may not know what a mailing affidavit is, so I'm going to show you a template form. That's a mailing affidavit right there on the screen. It is essentially a document where you have a notary public witness you dropping a letter in the mail. I've worked in a lot of different government buildings and in almost every state agency and every city government that I've been in, there was somebody around who was a notary clerk. May not be true in every small town, but there's notary publics all over the state of Kansas. In my previous job working at the courthouse, it was easy for me because the notary public in our building was the same lady who carried the mail from the courthouse to the post office. So she would witness me handing her the mail. That was pretty easy. She even found a typing error one time in one of my documents, and I was able to fix it before the letter got sent out. So a double bonus for using her. Had a property owner who came in. He came in because I'd sent him a violation letter, and yet he claimed he never got my violation letter. All right, I'm kind of suspicious that why'd he even come in if he never got my letter? But I pulled out my mailing affidavit from the file, and I asked him where he lived. And then I showed him this piece of paper that said I had sent a letter to that exact address. Well, at that point, he hemmed and hawed, and he kind of just basically shut up about that not getting a letter nonsense and started talking to me about his violation, which was a go-kart track in the floodplain. And he was selling commercial licenses for people to come and ride on his go-kart track, BMX track. And his neighbors had turned in a complaint, and he had offered to let them have a free membership if they wouldn't complain about the noise. And they were the ones who turned him in to me. Neighbor complaints, I told you. All right, now, violation letters of allegation. So there are several different kinds of violation letters. I'm going to start at the beginning. It's too late for a stop work order because the construction's complete. So you want to send a first notice of violation. And a first notice of violation kind of has a format to it. A second notice of violation is very similar to the first notice of violation, but it tends to dwell more on the enforcement. So a first notice of violation might say something like, a violation of our floodplain management codes is a misdemeanor with a fine of up to $500. I hope you'll work with me so we don't have to go through that. Well, second notice of violation means they've ignored your first letter. So with this letter, you're going to send them one that says, violation of our floodplain management regulations is a misdemeanor crime with a fine of $500. Each day that the regulation or that the violation continues is considered a separate offense. If you don't contact me within 10 days, I'll be forced to turn this matter over to our city attorney. So you see, you beef up the enforcement language. You make the second letter a little more threatening. I used to like to call the first notice the nice letter, the second notice the mean letter. A few bullet points about those letters. Don't say things like BFE. It's an abbreviation that we all know means base foot elevation. Don't even say base foot elevation because the average property owner doesn't know what that means. So watch out for acronyms. If you use a term that you don't think somebody's going to understand, find another way to say it or explain what it means. Be specific about the nature of the violation. Don't say the shed's ugly. Say that Article 3 of your regulations require a permit for new development in the floodplain. And Article 4, Section B, requires anchoring and openings. That's how you be specific. Okay? All right. Let the violator know that a response needs to be taken. So you want your letter to generate action. The letter of allegation is kind of neat. It's like a magic trick. It's written in much the same format as a first notice of violation, except you don't say that there's a violation on the property. You say that there's an alleged violation on the property. You say, I've had a complaint. The complaint is that there's a shed on your property and that it doesn't, and a search of our records could not locate a permit for this shed. It's believed to be in the floodplain. I will be there at 3 o'clock on Tuesday to investigate this shed. You mail out the letter about a week in advance. Now, the property owner gets this letter about a week before you show up. If you say you're going to be there at 3 o'clock on Tuesday, you show up at 3 o'clock on Tuesday. Don't be late. What happens is some of the people who get these letters, they either come down to your office and apply for a permit, or they move their shed. When you get there, there is no shed to see, or you already have a permit in hand and the problems have resolved themselves. We're not trying to find problems. We're trying to find solutions. And the allegation letters sometimes magically create solutions. So that's the thing I like about allegation letters. You can consider your allegation letter your first notice of violation if you like. Now, where do we send these letters with our mailing affidavits and our certified mail? Send them to the owner of record of the property. And you can check with the Register of Deeds. As I said, I worked in the courthouse, so I was one floor above the Register of Deeds. That was pretty easy for me. But you can usually do that pretty simply, even if you're a city official. You can request a limited certificate of title through your attorney. One of the things you don't want to mess around with is just sending the letter to the address, because the owner may not live at that address. The property may be rented. And the problem with tenants and landlords is that the tenant may have created the violation. If you send the letter to the tenant, he'll tell you, well, it's not my property, go talk to the landlord. You go talk to the landlord's going to tell you, well, the tenant did it, go talk to him, he's living there. And they're going to bounce you back and forth like a ping pong ball. And then what happens is, if it's going to be expensive to correct the violation, the renter is just going to move away and rent a new house somewhere else and leave that violation behind. So you don't want to fool around with that. What you want to do is send it to the owner record of the property. That'll be the landlord, the owner of the house, and let the landlord deal with his or her tenant. Earlier, I talked about state statutes, and you saw there was a state statute for abatement. Abatement is when the cost of correcting a problem is added to the property tax as a lien against the property, and the owner of the property is forced to pay it when they pay their property taxes. It's commonly used. Has anybody ever heard of a mowing order for somebody's grass being too tall? The city crew goes out there and mows the grass, sends the property owner a bill. Property owner doesn't pay the bill, then the cost of that bill is added to their property tax as a lien against their property by the city. That's abatement. That's how it works. Tenants don't pay property taxes. Owners and landlords do. So you want to send the property owner that notice. How's the letter sent? Pretty much send it the exact same way that we talked about with certified mail or mailing affidavit or both for the letter of allegation and the stop work order. Now, maybe you're dealing with a corporation, a business entity. So this corporation could be a company that's overseas or something like that. So you need to find a local address to send it to. You can go to the Kansas Government Business Center, and on the Kansas Government Business Center, you can do a business entity search. I've got the steps laid out for you here, but you're looking for the resident agent. So you do a business entity search. Say you're looking for the resident agent's name. That resident agent is the local authority that's authorized by that company to receive your letters of violation for their company. Once you type in the name of the company, you can get their address. This particular one, just real quick, I love this one. It says that the owner's resident agent is the corporation company incorporated. Now that's a mouthful of nothing, isn't it? All right. Now your violation letter should have different things in it, and it's sort of like a template. You lay it out with these specific layers to it. And when I think of layers, I think of a bacon, lettuce, and tomato sandwich. So your top slice of bread is your opening greeting. Then you explain the nature of the violation. Shed doesn't have anchors. Give them the specific citation. Article 3 requires permits for development of the floodplain. Request a meeting. We want our letters to generate action. Sure, we want them to get a permit. We want them to anchor their shed, put openings in it. But sometimes the action we want is for them to meet with us to discuss how to put openings in. If they go and put in openings and they do it wrong because you haven't met with them and had a good discussion about how to install openings or what kind of vents to use, that's a problem. But we want the letter to generate action. Explain the consequences. Explain them at length in your second letter. Touch on them in your first letter. Explain they have the right to an appeal. If somebody comes to you and they say to you, is there anything else I can do? And you tell them, no, there's absolutely nothing else you can do. And you don't tell them that they have the right to apply for a variance. You've effectively denied them a variance and violated their rights to apply for a variance. When you violate people's rights, courts take a dim view of it. Give them a deadline date to act. First violation letter I ever sent, I was inexperienced. I did not put a deadline date in my letter. The guy was really nice, but he said, I've been meaning to get back to you, but there was no deadline, so I kept putting it off. So after that, I knew I always needed to use deadline dates in my violation letters. I told that guy was really nice. He took care of the problem. It was a bunch of junk cars, and his wife actually sent me a thank you letter. When was the last time you got a thank you letter for doing your job? His wife had been after him for years to get rid of those junk cars. Now, this is a violation letter. It's not the worst one I ever saw. The worst one was in a community that had been flooded twice, and the floodplain manager had never issued permits to do repairs or done damage estimations like he was supposed to do. So he got audited, and FEMA told the community that they were going to kick the community out of the NFIP if they didn't go in and address these problems, and required them to do after-the-fact damage estimations, make everybody who had repaired their flooded homes get permits. So that guy sent out a letter, and the letter essentially said, the state of Kansas is forcing me to send you this letter. Please contact my office within 10 days with your plans to demolish your house. That's what he said. That's honest to God. That's what the letter said. Now, I said that you wanted your letters to generate action. That letter generated immediate action, let me tell you. This is the second worst letter I've ever seen. So let's go through it, look at it real quick. So it has an opening greeting. I told you to send your letters to the owner of record of the property. This letter says, to whom it may concern. Well, imagine this goes to court someday. Can you subpoena to whom it may concern or file a court case against to whom it may concern? No, you file your court cases against individual people. So this isn't a good way to start the letter. I know one of the people who got one of these letters. He said when he got the letter, he wasn't concerned, so he threw the letter away. Don't say dear sir or madam either. That's almost just as bad. Address it to somebody specific. Explain the violation. Well, this letter, front line, says, as of now, you are in violation. And violation is in bold print, all caps. Very accusatory. Well, the property owner is not in violation. The property is in violation. The shed is the violation, not the individual who's reading the letter. You're in violation of our county's floodplain management regulations. Not very specific. What he's actually saying is you've done something wrong. You're a bad person. And if you want to know what you did wrong, read our entire floodplain management regulations and figure it out for yourself. That's what it's saying. And that's not the way to do business. There is no citation given. It doesn't request a meeting. What it says is if you have any questions about this letter, call within 30 days. Well, if they don't have any questions, they're not going to call. And what other action does this letter generate? Quite often letters like this generate no action at all. Explain the consequences. This is his first notice, says so right at the top. But his paragraph about the consequences is 4 times longer than any other paragraph in this letter. In fact, it constitutes almost half of the letter is all about the consequences. I'd hate to see a second letter where he gets mean. Give him a deadline date to act. Well, he gave him a deadline date to call, but he didn't request any action. He didn't request a meeting. He didn't tell him to fix anything. So essentially, he hasn't given him a deadline to do anything. And a conclusion. And after sending him this really bad letter, he says, respectfully yours. Are you ready? Well, again, I wanted to hit on this deal of a deadline date. Deadline dates are vitally important. Look at the floodplain management violation section of your city ordinance. I bet it's pretty lightweight because the state of Kansas template for that is pretty lightweight. You might want to beef it up with more information about how you're going to investigate and act on violations, or put that information in written administrative procedures that accompany your ordinance. Have these things in writing. Nobody's ever going to say that you treated them different than anybody else if you did exactly what it says you're going to do in your written administrative procedures or in your city's ordinance. Look at how other departments, so if you're from a larger city and you're the floodplain manager, there might be zoning, code enforcement, building codes. How do those departments handle violations? Try to make yours similar to theirs so that there's consistency between departments. And if a shed is in violation of zoning setbacks and floodplain requirements because it's in the floodplain without being anchored, put all of that information in one letter from both your departments at the same time. The 5th and the 14th Amendment of the Constitution require due process. There's that There's that dreadful document, the American Constitution, coming up again, interfering with us being able to enforce our rules and regulations. But because due process is written right into the Constitution, people seem to think that they have the right to due process. And what is due process? Due process means giving people a reasonable opportunity to correct a problem. Okay? So if you send them a letter that says, yeah, you have 5 days to clean this up, you haven't given them due process. You need to give them a reasonable amount of time. What is reasonable is basically the essential behind due process. I consider 2 written notices as being reasonable, especially if you give them a reasonable amount of time to act on both of those notices. Copy your letters to the state NFIP coordinator, okay? Make them the bad guy. We'll be the bad guy for you on that. Don't make me the bad guy without talking to me first, though. But put my name down on the bottom of your letters, copy to Steve Samuelson, NFIP Coordinator at Division of Water Resources. It's going to make your letter sound more official. And if a property owner comes to you and says, what can I do? You say, well, you're going to want to work with me because I'm a lot nicer than mean old Steve Samuelson. You should also copy your letters to our Water Structures Program office in Manhattan, Kansas. They will look at it. Janelle Phillips is wonderful. And if they think that this is a violation of our requirements under DWR, then the property owner will get a second follow-up letter from the state of Kansas through our Resources Water Structures Program. So that gives you impetus to get things corrected because they have not only you to deal with, but the state of Kansas. That gives you twice as much weight when you're dealing with enforcement. We want to get problems solved. Now, inspecting violations is the first step in the process. All right. The second step of the process will be discussed in tomorrow's seminar. That's where we're going to be taking action, resolving problems, meet with property owners. Sometimes the action we take to resolve a property owner means taking them to court because they refuse to work with us. We'll talk about that more tomorrow. If you have any questions, I'm Steve Samuelson. We're going to open up the lines to do some Q&A here in a minute. I'm going to leave that screen up for just a second so that you can all get Cheyenne Sun Eagle's email address. Hopefully most of you know what it is already. And then I'll stop sharing in about 3, 2, 1. Thank you. Hey, there's a whole bunch of people on this seminar. I just now saw the participant list when I quit sharing my screen. So hello, everybody.
All right, thanks, Steve. Yeah, there aren't any questions in the chat function right now, so
that either means I did it perfect or I just hopelessly confused everyone. Since there's no questions, I'll just say this. If somebody has a local violation issue and they'd like to discuss it with me offline, one-on-one, without being, in this meeting, I'd be happy to talk to you about
it. Hey, Steve.
Yes.
Steve Higgins, how you doing?
Doing better than you, Steve.
Yeah, good presentation. Hey, I did write write notes down. You're moving on there. Sending a copy of the DWR. Are you talking about sending one to you and to Janelle, or?
Yes, and the easiest way to do that would just be to send an email with your letter attached to it.
Okay, yeah.
And you can just email it to Janelle Phillips and to myself at the same time. If you send me an email and say, hey, Steve, here's our violation letter, but I forgot Janelle's, address or something, I'll forward it to her. Okay,
right. Good. I did not know that, or if I forgot it.
Well, it's dual purpose. I keep copies of those violation letters in my files so that if FEMA ever says, hey, what's going on in Riley County? We saw this new highway being built in the floodplain. I can say, well, they're getting permits for that, or this property is in violation, and here's a copy of the violation letter the floodplain manager already sent to me. Janelle's purpose is to get those DWR permits on the ones that are jurisdictional under her rules. Some things are not jurisdictional for DWR, but everything in the floodplain requires a permit under NFIP. But in the cases where it is jurisdictional under DWR, you get the weight of the Division of Water Resources backing you up when Janelle sends them a violation letter. Does that make sense?
Yep.
All right.
Very good. Thanks.
Look here, Janelle typed her email address in the chat box for everybody to see. She's just glutton for punishment.
And I'm pretty sure I could send out these PowerPoint slides to everyone.
Yes, you can do that.
And the
We also,
credit.
I talked about an allegation letter. We got some things like a sample allegation letter if somebody wants to see one. We have a little handout of tips on how to write violation notices. So instead of me so if you want that, just ask Cheyenne for it. It's very similar to an article that we ran in our newsletter a while back, but my newsletter is limited on space. So what was a 2-page article in my newsletter is a 3-page handout that you can have.
Great.
Also,
And
if you want to see a template for a mailing affidavit, got that as a Word document if anybody wants one of those.
Yeah, just anyone let me know if you need that. And then how people can receive credit.
Right. And yeah, so let's just hit that right now before we run out of time. How do you get the CFM credits is you will send Cheyenne an email and say, I need my CFM credits. Or if you just want a certificate for attending the class, you send Cheyenne an email. She will email a certificate back to you. Now we're doing more of these classes tomorrow, so give Cheyenne a couple of days to respond to all those because she's pretty busy. So once you got your certificate in hand, you can turn that in with your request for CFM continuing ed credits when you renew your certification. Right.
Okay,
Hey, Steve, this is Roberto. Thank you for the presentation. Appreciate it.
Well, sure. Thanks for driving all the way in from Garden City to attend this class.
Hey, not a problem. I'll do anything
Right.
for you, Steve.
This was the easiest commute for a class you've had in a while, I know.
It is. Thank you.
Yep. Sure, Roberto. All right.
Hey, Steve, hold on a second. On that, when you talk about sending them off, I don't know which conference we was at or whatever, but I've been doing it since, been several years ago. As I get my certificates of training, they asked me to go ahead and just email them into them, and they'd have them on record. They're at
They were ASFPM has recently updated their website. And I think they were trying to create a template on their website where you could actually download your certificates by going to a link off their website directly to them. Which is a little beyond the violation stuff. Get with me about that later if you got questions, Steve.
Yeah, I'm just saying it's been great if people do that. Then when it's time to renew, boom, there it is. It's all done.
They tell you that you've already got your document, your credit hours are documented and you're good to go. Then you get to send them the check for the fees. Well, we're really about out of time. So if anybody has any follow-up questions, they're welcome to call me direct. Okay. All right.
All right. Thanks, Steve. Thank you, everyone.
Bye, everybody.